Amy Dash joins us. She's Fox Sports Radio's legal analyst. You can follow her on Twitter at Amy Dash TV. Amy, let's start with the actual ruling, because the very first line I read was that the Supreme Court has chosen at this time not to change anything that the NCAA does in terms of eligibility for and restrictions on student athletes, with the exception of education-related expenses. What does all that mean?
All right. So first of all, to clarify, because I think this is confusing for a lot of people, it's a very dense opinion. So the Supreme Court actually had its hands completely tied. It could not address at all the athletic compensation to student athletes, the non-education related, I should say, compensation to student athletes. The only question that it could answer is, was the lower court right in allowing athletes to get more education-related benefits? So the lower court said that the NCAA has to allow more education-related benefits, paid internships to vocational schools, anything related to education, fine. The lower district court did not accept, I should say, the student athletes' reason for bringing this case, which was to say that all of the compensation restrictions by the NCAA violate the antitrust laws. The lower court disagreed, but this is what's so fascinating. The Supreme Court never got the chance to answer that question because the athletes never brought that question to the Supreme Court. They never challenged the lower court ruling. So because of that, the Supreme Court could only sort of give its cursory opinion, and that opinion seemed to favor that it would have ruled for the student athletes on the compensation front. And so the Supreme Court sort of criticizes the student athletes and says, why did you give up this fight? Why didn't you challenge the lower court ruling saying that you only get extra educational benefits and that you're not entitled to compensation across the board? Why didn't you challenge that? I mean, you have the major Supreme Court Justice Kavanaugh, writing his concurring opinion saying, wow, this was a major fail for student athletes. Clearly, the compensation rules here violate the antitrust laws. You have undisputed facts in this case. The NCAA does not dispute that it's a monopoly. It does not dispute that there's been a conspiracy of sorts where it's agreed with other members to price fix. Sure. It does not dispute that this has lowered the salaries available and the competitive nature of student-athlete labor. Why didn't you go for it?
So what's the next step?
So the next step now is that actually the court puts out this entire test that can be used in future cases if athletes bring more litigation, which it sort of invites them to do. And it says that you can actually challenge every type of restriction put on you in terms of compensation by the NCAA. And when you do that, the court has the authority to go through each and every restraint on compensation and decide, is it reasonable? Does it further the NCAA's goal of being competitive in the marketplace? And if it doesn't, and it harms the student athletes, it shouldn't be allowed. So they're basically saying, the NCAA is saying we need all these restrictions on compensation in order to create this amateurism model. The Supreme Court says we don't even know what that means. You've never effectively defined what amateurism is, and it's even been shown that there's even more consumer demand than ever before, even as you've started giving more and more to athletes, according to what you decide you should be giving them. So they're questioning whether there's any pro-competitive advantage to the restraints on compensation for athletes.
It's fascinating to me because I think that one of the big, it's like the elephant in the room that I don't believe has been discussed enough is like basically universities and sports programs operating in this tax shelter, right? Where they're able to make money. And look, universities make money off all their students, not just their athletes. That's the truth to it. And then they ask for those same, alums to give back as a tax credit, right, to their university. Additionally, all the benefits the student athletes want to receive likely would be taxed as well. How would that be navigated, do you believe, when we get to a model where there's some form of additional compensation.
Well, that's sort of what the court says needs to be figured out, and they said maybe that could be figured out through legislation. Maybe there should be a union, one of the justices said, where they're, negotiating the student athletes for a portion of rev share similar to the professional leagues. But I think what the Supreme Court also says is be very careful. There is a pro-competitive advantage to having a distinction between professional sports and college sports.
Sure.
So if you go too far where you're paying these athletes professional-like salaries, then there's not going to be so much demand for college sports because it's the one bleeds into the other, right? So they're saying there has to be a reasonable balance.
I do think that there would be. Look, people watch. The truth is, people watch because of their school. They don't actually watch because of the athlete. And I do think that's one of the issues with the NCAA, that they're not willing. They have yet to present a smarter case, which is, hey, just look, it does not actually matter who's wearing the uniform. For the most part, if you put the uniform on, people are going to watch in their area and those alums. And then, of course, that draws the better athletes, et cetera, et cetera, et cetera. That said, I think it's going to be fascinating to see kind of what this all kind of ends up looking like, and how, because the NCAA is kind of relented on the name, image, and likeness stuff. But what does it all look like in the end? What is the end game to this? Because the idea of a college scholarship is to get people into college and then to give them the ability to pay for college, which is more expensive than others. And if we make it more expensive to support these athletes, well, then less student athletes will get the opportunity to be student athletes. Make sense?
Yeah, and I think you're exactly right. But also think about it this way, which I'm sure you would agree with, that everything the NCAA is giving, there's an exploitative back end to it. So they're deriving a benefit from these scholarships.
So, hold on, but go ahead. Tell me the exploitative, because I actually think the opposite. I actually think, and this as a former student athlete, I actually think that student athletes, like my whole career has been built upon playing in college and who I played for and the promotion of me there. So explain the exploitative nature of it.
Okay, so you give a student a scholarship, right? And you act like you are the noble saint whatever because you are giving this student something in exchange for all the money that they're making you. Okay, let's say the student, as Justice Kavanaugh says, most of the athletes that are being used by the NCAA, and the NCAA is making millions and billions off of them, and the coaches are making millions, and the president of the NCAA is making millions. Okay, most of these kids that are not being paid are low-income African-American students. So you give a scholarship, and you say, well, we're paying you back by using this scholarship for everything you're giving us. But the school is deriving a benefit because those students may not have been able to afford college. So now the school is able to use a scholarship to recruit a top athlete that's going to make it a fortune under the guise of, look what we're giving to you. Well, how about look what that athlete is giving to the school when the school makes hundreds of millions of dollars off that athlete's name?
Okay, so tell me first of all, there's a couple of things here. One, it's harder to get into school than it ever used to be. We agree there?
Yeah.
Okay, so it's one of the benefits.
Unless you have an extraordinary talent at a sport, then they want you.
I understand, but so we're agreeing that you're like, well, what are they all giving you? They're giving you in to a university you couldn't get into on your own. You just couldn't. You couldn't apply and get in on your own. I couldn't have gotten Notre Dame on my own without being a student athlete. Couldn't have afforded it. Okay, so then schools are more expensive than ever. So like we're talking an exorbitant sum of money, and then of course you have all the resources to support you in both your sport and in academics while you're there. Tell me the student athlete, the individual student athlete who's worth these hundreds of millions of dollars that we're proposing are kept from them. Like if you're a basketball player, there are other avenues that if you're so valuable, you don't have to go. If you're a football player, again, that's an NFLPA rule. But again, you don't have to go. So where does the, where I don't understand the exploitative nature of going somewhere that's going to support you, promote you, get you into and pay for a school that you couldn't get into or pay for on your own.
Well, I think you have to do a cost-benefit analysis. So
Sure.
let's say under your theory, the person comes in, they get the degree, they don't go on to professional sports, right? They end up going and becoming like a real estate broker or a teacher, or they use their degree for something that's going to support a career that's going to enrich them for the rest of their lives.
Yes.
Okay, well, now you got to weigh that against how much money did the school make off of them? And should they have gotten some sort of a balance? Should there be a balancing of what they are getting from the school versus what the school is getting from them? Should it be more proportionate? And that's sort of what the Supreme Court is saying here is there has to be a balancing where the athletes get closer to their market value of their services that they're providing because it is labor, right? But then also there has to be a benefit to the school as well in terms of being able to offer this, this industry of college sports to its own consumers so it can make money.
Yeah, I don't. The money that you're going to make with a college degree and having played for a university is exponentially better than the money you would make if you didn't have that college degree, or even if you just went to a school and didn't play in college athletics, right? Like if you walk in and you're in the area, especially if you're in the area where you played, to an alum, you're going to get the job. I mean, we all kind of know that to be true. And that's 99% of the kids. And then the other percent go off of their name, image, and likeness, make money for years to come based upon even their successes in college while they go and pursue college. The other part to it is, like, the Olympic sports, there was a young woman from Vanderbilt who I thought was very, very eloquent. But, I mean, she's completely lost on the economics of it. She's like, well, it's known that the NCAA doesn't like to promote women's sports. Like, well, that's not true. They like to promote it. People just don't want to watch it. They can't make money off it. And all these other sports that they can make money off support your sport, right? There's the Title IX element to it is another kind of non-discussed factor in how they navigate this in the future.
And that was, by the way, brought up in the decision. So you're wise to bring that up, too, because Justice Kavanaugh said there's a lot of questions, that this is not simple. And the court said this is not simple, too. And maybe it's not best for a court to be able to figure all this out because it could do more harm than good because you've got the question, like you said, of the Title IX, but also the schools that make money supporting the schools that don't, the sports that make money supporting the sports that don't. How is it all going to work economically? And then you've got the threat of lawsuits, which I think is the biggest problem out of this decision is now the NCAA should be terrified of a lawsuit. The university should be terrified of a lawsuit. This decision basically says anybody who's going to put any type of a restraint on compensation for an athlete can be challenged in a court of law, and the court can examine that restraint and see whether it is fair under the antitrust laws, whether it overburdens competition in the labor market for athletes, and whether it's important enough to preserve the college sports industry to keep it. That's going to be sort of the balancing test. So there's going to be a lot of litigation over every single little thing here.
Amy Dash joining us. She's our Fox Sports Radio legal analyst. Can you dumb something down for me that honestly I think most people don't know?
Yeah.
When we hear antitrust legislation, right? We feel like that's anti-monopoly. There are businesses, there are sports, there are parts of our society which are allowed to violate antitrust laws. What are those businesses?
Well, that depends. First of all, Congress can give an exemption, right? So like we know Major League Baseball has an exemption from antitrust laws. Interestingly enough, people have gone back and tried to expand that to other professional leagues, and it's been rejected. So there's not really a huge rhyme or reason to it. Congress can enact a law that says the NCAA is no longer subject to antitrust law. Either way, I think after this decision, you need Congress to step in because you've got all these rules that are about to go into effect now in terms of what athletes can profit off of their name, image, likeness, endorsements. They vary from state to state. It's a huge mess. Yeah. Now the NCAA has been completely invalidated in its authority by the Supreme Court. You need some sort of uniform rule here. The courts can't the courts are saying now we've got a test, but like I said before, are you going to go litigate every single rule by every single university and the NCAA to see like which one's fair and which one isn't fair to the athletes?
Yeah.
You need some sort of a federal bill here right now to clarify all this stuff.
Well, of course, Congress can figure it out, right? They can. No problem. But the other part to it, though, and as you said, they invalidate the NCAA, but the NCAA is just the legislative body for all the member institutions, right? So even if the people of the NCAA goes away, like we have to have something that ties all these schools together. You can't have anarchy, can you?
I don't know. I think the major problem here that they underscored is that look at how much money they are bringing in off the backs of these student athletes. Hundreds of millions, billions. And I think the really important point that they brought up is, listen, in the 80s, there was this decision board of regents, that said, oh, yeah, the NCAA has this interest in maintaining amateurism, whatever that means. It's really important. Well, this court says from the 80s until now, the landscape of college sports and the money that it generates has drastically changed. And you have to take that into account when you're looking at, this is a commercial business. This is a profitable enterprise. And how profitable it is matters because they're using labor from student athletes to generate that profit. So for them to be making hundreds of millions, billions of dollars, and you've got coaches with $10 million salaries, you've got the president with $4 million of the NCAA with a $4 million salary, and then they're sitting here fighting over whether to give the athletes an extra couple $1,000s for their books and supplies. It's just unjust. And so that's what the concurring opinion said. And what's really, really of note, Doug, is that the majority said our hands are tied. We cannot rule on any other element of athlete compensation besides the educational benefits that were given to athletes in the lower court. And then you have one judge who comes out with a concurring opinion, which means he agrees with the majority, but he wants to take it a step further. And he just goes off on the fact that the NCAA...
But that's also one judge, right? Like, do we take that to believe... Huh?
Yes. It's a landmark opinion, his concurring opinion.
Well,
because it forms the basis for future decisions. It says the NCAA has point-blank violated antitrust laws, and that means that it has a monopoly. It's preventing competition in the marketplace. It's hurting labor. They say that he says no other industry would this fly. You cannot price fix what the people who are working for you get and put a cap on how much they can make while you are benefiting exponentially off of their labor. And he basically says the remaining compensation rules here, they need to go under judicial scrutiny. They need to be examined because he doesn't believe that there's any way that they would pass muster, meaning that the courts should and probably would find them to be illegal if they take the Supreme Court's lead. And the Supreme Court is the leader in the judicial system.
Yeah.
So for him to be saying that, there's going to be a lot more litigation unless the Congress steps in here.
As our friend Andrew Brent says, there will be lawyers. Amy, great stuff as always. Excellent perspective. We really appreciate you joining us.
Oh, of course. Thank you. Thanks for your passion on this.